Hello and welcome to Everyday Law, the show that demystifies the law for you and your family. I'm your host, Attorney Robert Monahan, and on this late December day in 2017, one of the last days we have in 2017, I'm filming alone. Today I don't have a guest, it's just me. So I'm looking forward to talking to you. Again, I'm your host, Attorney Robert Monahan, and today we're going to be talking about the pros and cons of using LegalZoom to draft your will. LegalZoom has some advantages, it has some disadvantages, and so many people know that they need a will to protect their family, and yet they hesitate. They don't know whether they should use an attorney, if an attorney is worth the time and expense, the effort. Who wants to see an attorney, especially around the holidays? And then they think, well, maybe I could draft my will myself with the online tool like LegalZoom or Rocket Lawyer, some online do-it-yourself kit that you can use to draft your will. And then they hesitate about that and they wonder, well, will LegalZoom do everything I want? Is Rocket Lawyer really safe to protect my family? Will it give me the peace of mind that I'd like to have when I'm done with the process? And as a result, often the will just doesn't get done. And from an abundance of options, you don't know what to do. You don't know if you should use a lawyer, use LegalZoom. Is the lawyer worth the money? Is LegalZoom is LegalZoom safe? Is Rocket Lawyer safe? So from an abundance of options, often the will doesn't get done. And today we're going to talk about several things. We're going to be talking about why you need a will, what it does, some key provisions in a will, and then the 5 things you need to know before you use LegalZoom to draft your will. Before we get into that, just so you know, the LegalZoom kit is a lot like the TurboTax kit. TurboTax is an online service and a service you can buy on a CD or a DVD. And what TurboTax does is it lays out a questionnaire for you. And by answering those questions, you do your taxes. It's pretty simple. You answer questions about your income. You answer questions about your expenses, your activities through the year, and bang, out pops a tax return. And LegalZoom is sort of the same in principle. It asks you, again, a series of questions. You provide the answers, and by providing the answers, out pops your estate plan, your will. And the question that I think people want to know the answer to is this: is LegalZoom really as good at an estate plan as TurboTax is at doing your tax return? Are death and taxes really the same kind of thing? And that's what we'll be getting into after we talk about will basics, kind of why you need a will, what a will does for you, and kind of the key provisions in any will. So let's begin with the basic question of why do you even need a will in the first place? I think everybody knows they need one, but they're not quite sure why. The reason you need a will is if you don't have a will, the government has a will for you. I think Ronald Reagan said the 9 most terrifying words in the English language are, "I'm from the government and I'm here to help you." So if you don't have a will, the government has a will for you. There are default rules that the government's put in place. These are called intestacy rules. If you don't have a will, the law of intestacy applies to you. If you die intestate, you die without a will, and the government decides things for you that you could decide yourself. The government plan of intestacy decides who will administer your estate. It decides who will be your beneficiaries and get your property. And if you have minor children, it could decide who will be the guardians of your minor children. And if you're comfortable with that, I'm surprised. We live right here in the state of Illinois, and it's hard to trust the state of Illinois with just about anything. And the government doesn't know you. It doesn't know your loved ones. It doesn't know what you want in your plan. So you could really take control of your destiny and draft a will yourself to take yourself out of the laws of intestacy. Because the laws of intestacy they're what the government imagines the average ordinary person would want for his will from statistics and data sets. But you're not a statistic. You're not the average result of a data set. You're an individual with your own loved ones and family. So you should be making those decisions, I think, for yourself by drafting a will. And the next thing I want to say is when you die, whether you like it or not, your estate is created for you. When you pass away, your estate comes into being. And just like Mitt Romney, another Republican, said about corporations, estates are like people, my friend. An estate is like a person. It has a checkbook. It has assets. It has liabilities. It can invest in things. It can invest in corporations, my friend. So it has a social security number. So an estate is like a person. And if you die with a will, you decide who administers your estate, who is in control of it, who the beneficiaries of your will are, and who the guardians of your children are. So your estate is basically your property, your car, your house, your stocks and bonds, and so on. And you have an estate whether you want one or not when you pass away. And that's really why you need a will. You need it to protect your assets, to protect your children, to appoint who you want to administer it for you, and to make what happens to your estate when you pass away follow your desires rather than the desires of the government. In this second section, we're going to talk about the most important sections of your will: the declaration section, the family section, the debt section, the distribution section, the executor section, the guardian section, and the bond section. It seems like a lot, but a will it's a big document. The first part of any will is the declaration section. In this section, the testator, that's the person making the will, declares that he is making his will, that he knows he's making his will. He says his name, he says where he's from, and he revokes all prior wills, all prior codicils. And a codicil is an amendment to a prior will, or an amendment to any will, really. It sounds like this. I'm going to use Zeus as my example because he's not copyrighted. So, I, Zeus, a resident of Mount Olympus, being of sound mind and memory, do hereby make, publish, and declare this to be my last will and testament, thereby revoking and making null and void any and all other last will and testaments and or codicils to the last will and testament heretofore made by me. It's a lot of legalese, but what that basically says is that Zeus is making a will. He lives in Mount Olympus, and he's revoking all prior wills, all prior codicils. That makes them null and void, and this is the will that counts. So when you make a will, you'll do the same thing. You'll say, I, John Smith, revoke all my prior wills, and I live in Waukegan, Illinois, or something. So that's how that would go. The next section is the family section. The family section describes your children by name, who they are, and it also describes that you include any afterborn children in your will. You make provision for them as well, and any after-adopted children. Those are children that you adopt after you make your will. This section would sound like this. At the time of executing this will, I am married to Hera. The names of my children are listed below. Unless otherwise specifically indicated in this will, any provision for my children includes the below-named children, as well as any child of mine hereafter born or adopted. And the children are Aphrodite, Ares, Elithea, and Hebe. Those are 4 of Zeus's children. I don't know if he had more, but those were the 4 that I found in the book on Greek mythology. Similarly, if you had a will, you would say, I am married to Mrs. Smith, and I have 5 children, Janie, Freddie, Jimmy, Ben, and Sarah. And that would be your section with a lot of other legalese thrown in. The debt section of the will says that you'll pay your debts and taxes, or that your executor is authorized to pay your debts and taxes, including things like illness expenses, funeral costs, attorney's fees, estate administration costs. But your executor will pay these only after the claim has been presented and proven to the satisfaction of the probate court. And then after your debts are paid, your executor will make a distribution of your remaining assets. So the estate consists of all your assets. Out of those assets, your executor pays your debts first, and then distributes the remainder to your heirs. Your will also appoints your executor. Now, do you remember how we said an executor is like a person? It can have a checkbook, it has a social security number, it has assets, it has debts, it can make investments, and so on. It can't do that by itself. It needs an executor to act for it. And your sentence nominating your executor is very simple. In Zeus's will we have, I nominate my spouse Hera to be the executor of this will. So when Zeus dies, if he dies first, Hera will become his executor and follow the instructions of his will to the letter. Another provision that's very important for any family with little kids is the section that appoints a guardian. Your will is the document that appoints a guardian for your children if something should happen to you and you know who you want to take care of your children. Otherwise, it's in the hands of the state of Illinois or the state that you live in. The courts will decide who should be the guardian of your children. And this section is also pretty simple. Here it says in Zeus's will, I nominate Apollo to be the guardian of the person and estate of each minor child of mine. If he is unable or unwilling to serve or continue to serve as guardian, I nominate Hephaestus. So, again, having a will is so important if you have little kids because that takes care of nominating who will be their guardian if something should happen to you. And the last thing, and it's pretty important and not that well known, is that a will waives bond. It's simple language. It says, no person named as an executor is required to post any bond. Now, what is a bond and why would anyone post it when they're administering your will? A bond is required of any administrator or executor unless specifically waived in the will. And the bond is like an insurance policy against stealing from your estate or defalcation. So what you're doing when you're waiving bond is saying they don't have to go to an insurance company or any kind of bond company to buy a bond to protect my estate against any stealing from it while they're administering it. And those are the 5 or 6 most important provisions in any will. The declaration section, the family section, the debt section, the distribution section, the guardian section, the executor section, and finally the bond section. It's actually 7. So when we come back, we're going to talk about the 5 things you should really know before using LegalZoom to draft your will. Hi, and welcome back. There are 5 big things you should know before using LegalZoom to draft your will. LegalZoom is an okay service. It has advantages and disadvantages, but you need to know about the context of what you're doing in order to really do a good job with it. And the first thing I wanted to say about using a LegalZoom will is that I think, I have to admit it, lawyers can be difficult to work with. So the first point is that I can understand why you might want to use LegalZoom for your will. So that's the first kind of big point, that lawyers can be difficult to work with. The second point that I want to make is that LegalZoom is not a bad product if used correctly. It's fast, it's cheap, and it's super convenient, so it's not that bad a product. But the third thing you should know about a LegalZoom will is that a LegalZoom will does not cover all your assets. It only covers some of your assets. Any will only covers some of your assets, and that includes a LegalZoom will. The fourth point is it only covers certain situations. So your LegalZoom will does not cover every possible situation that you could want covered by a will. And what I'm really thinking about is incapacity planning. If you got struck by a car and were in a coma or started to suffer from Alzheimer's or dementia, your will would not be the effective document, and you need other documents that are usually part of an estate plan in place, and you really need to know that. The last point is there's a misconception about wills that I'd like to dispel right now, and that's that people think if they have a will, they avoid probate. I need a will so I can avoid probate, so my family doesn't have to go through the probate process. Well, the opposite of that is actually true. Having a will does not mean you avoid probate. It means you probably will end up in probate, and your family will have to go through the probate process, and they'll be doing it alone without a lawyer who drafted the will. For all those reasons, I think I lean towards advising a family to find a lawyer that they can work with to draft their will. But again, the first point that I wanted to make is that Why would anyone use LegalZoom in the first place? I think the reason is that lawyers have such a bad reputation, they can be very hard to work with. There's a famous joke that's called, what do you call 500 lawyers at the bottom of the sea? The answer, a good start. I've asked a lot of my friends who did try using LegalZoom why they did it. Why would they use a service like LegalZoom instead of a live flesh and blood attorney that they can ask questions to? And most of my friends had the same story. They said they did start with a lawyer, a live flesh and blood lawyer. And the problem with using a lawyer was he didn't answer their questions well. He didn't return phone calls. They couldn't see or understand what he was charging for. They didn't understand what the product was at the end of the day. And that is really a problem with the lawyers that draft these and work with people, is that sometimes they don't do a good job explaining what they're doing, answering questions, returning phone calls, and so on. So more and more people are using LegalZoom for their estate planning needs, especially when it's a standard, basic last will and testament. So LegalZoom, is it good? Is it safe? Should you use it? Well, I would say LegalZoom is good, cheap, and fast up to a point. You know, LegalZoom has grown so fast. I think it's been, I think I read a statistic that one person every 5 minutes drafts their will with LegalZoom. And first of all, a LegalZoom will is very inexpensive. I think a LegalZoom will costs about $69. The price of a pair of sneakers, that's about, I mean, the cheapest will that you could get from any lawyer is probably 10 times that or more. So LegalZoom will is very inexpensive, very hard to beat LegalZoom on price. When you pay a lawyer, you have to pay for his secretaries, his office, his utilities, his supplies, everything else that comes with having an office. When you use a LegalZoom will, you get a great deal. A LegalZoom will is also very fast. You can draft a will and get it back in 2 days. I think I tried the service. You answer the online questionnaire, and you get your will back in a PDF form in just a couple days. So it is fast, and it's convenient. I think when I did it in my dining room. I just answered the questions with my wife in the dining room. We sent in the questionnaire, and then in a day or two, we had back our LegalZoom will. And I looked it over, and it was not a bad product. Now, I know my way around these documents, so I knew what to look for, and it can do, if you know what you're doing, all of the things you need a will to do. But before you do that, before you use a LegalZoom will for yourself, you should know, like I said, it doesn't cover all your assets. It won't cover all your situations. And in the end, you're going to need a lawyer because it'll probably need to be probated in the probate court. Having a will does not mean you avoid probate, and LegalZoom will not send out a robot to probate your will for you in the probate court. So it's kind of what you don't know that can really hurt you, and what you don't know that that can really hurt you. So when you draft your will with LegalZoom, you have to be very, very careful. Hi, and welcome back. Remember the points we made. First, I understand why you might not want to use a lawyer to draft your will, because lawyers can be hard to work with. Secondly, a LegalZoom will can be cheap, fast, good enough, and it can work for a family. But there are 3 things you should really know beyond that that can help you when you're drafting your will. The first is that a will does not cover all your assets. The second is it doesn't cover all situations. And the third is that you'll probably have to probate your will at the end of the day anyway. So first of all, let's talk about what assets your LegalZoom will or any will governs. Here's a quiz. Let's take John, a guy named John. He has 4 assets. He owns his home jointly with his wife. He has a joint bank account with his wife as well. He has a life insurance policy that makes his wife the beneficiary. And finally, he owns a vintage convertible Corvette titled in his own name, which he got from his father. When John dies, after drafting his LegalZoom will, which asset or assets does the LegalZoom will govern? The answer, only one, the vintage convertible Corvette. But why? The short answer is that different assets transfer differently on death according to the type of asset it is and how it's owned. So in particular, there are three classes of assets, three buckets really of assets. There are jointly owned assets that pass by operation of law. There are beneficiary designated assets that pass by the operation of the contract. And then there are probate assets, which are basically everything else. And a will only controls one of them. It controls the probate assets, the last category. So jointly owned assets are not governed by your will, not by your LegalZoom will, not by any will. Jointly owned assets pass by operation of law. So John's home that he owned jointly with his wife and his bank account that he owned jointly with his wife pass automatically to his wife. Nothing else has to happen. John doesn't have to do anything. His wife doesn't have to do anything. No one in their family has to do anything. Jointly owned assets pass automatically from John to his wife upon his death because that is how jointly owned assets work by operation of law. Now, secondly, what about that life insurance policy? That's a contract asset. That's in the second bucket. That is a contract between John and the life insurance company that John pays his premium with the promise that the life insurance company will pay the benefits to his wife when he dies. It's a contract between John and his insurance company. And when John dies, the life insurance company pays the money to the wife, and the wife doesn't have to do anything but send in a form. She doesn't have to go to probate court. She doesn't have to go to any court. She doesn't have to consult with anyone but the insurance company that took the premiums from John. The only asset that's governed by the will, because the home, the bank account, and the life insurance policy are all non-probate assets, is the car, the convertible car. Now, what makes the car a probate asset? The thing about the car is it has a title, and there's no way for that to be transferred without someone signing the title over to someone else. Anything that's titled in one person's name is a probate asset. So when John dies and his jointly owned home with his wife passes to his wife, Jane, and Jane owns the home by herself, when Jane dies, unless she added a joint owner to that house is now a probate asset and is governed by probate court. And Jane will have to go to the probate court. Jane won't go to the probate court. Her executor will, to liquidate the house and distribute it to her heirs. Again, someone needs to be there for a probate asset to sign over the title to someone else so that person can take title to it. So anything that's titled in an individual person's name is a probate asset. And only probate assets are governed by your will. Now, that's the third point I think I wanted to make about LegalZoom wills. The fourth point I wanted to make is that a will does not cover every situation that you would want covered. It may not give you the peace of mind that you want. The peace of mind that you think you're getting from your will may be just a mirage. There's much more to estate planning than just drawing up a will. Your will doesn't cover things that happen to you that leave you alive but incapacitated. A will only comes into its purpose after you die. But if somehow you lose function of your mind, your will doesn't come into effect, your power of attorney does. And a power of attorney is in two flavors. There's a power of attorney for health care and a power of attorney for property. And those two documents appoint an agent to act on your behalf when somehow you can't act on your own behalf because of incapacity. So if you get dementia, if you suffer from Alzheimer's disease, if you get in a terrible accident and you're in a coma, you need a power of attorney in place because your will won't do anything for you. Your will won't be effective then because you're still alive. You're incapacitated, but you're still alive. And a guardianship proceeding in probate court is what you would need, is what your family would need to undertake to protect you in that situation. Your family would have to petition the probate court for the appointment of a guardian to look over your health care needs, your property needs, until you regained lucidity, came out of your coma, or you ended your life. And that guardianship proceeding can be very expensive, between $5,000 and $10,000. So not only do you need a will in case you pass away or when you pass away, but as part of your estate planning, you really need powers of attorney, because a will only is effective when you die, and powers of attorney are effective when you're alive but incapacitated, and a will has nothing to do with that. And that's something that everyone should know. Welcome back. We're wrapping it up now with our fifth point. And our fifth point is that a LegalZoom will, or any will at all, doesn't necessarily avoid probate. I've talked to bank tellers before, and they've told me the story of someone coming into the bank with the will, saying, I'm here with the will, I was appointed the executor, I'm here to collect the funds from my dad's account and distribute them to the heirs, like the will says. And the teller says, well, I can't give you the will, that's not what I need. And the person will ask, well, what do you need for my dad? I have the will, this is what I have to follow the instructions. And the teller has to say, look, you need to go to probate court. You need to go to probate court and get letters of office, because by itself, that will is not effective. A will is not the effective document that allows the executor to act. The effective document is called letters of office, and only the letters of office allow the executor to act. And to get those letters of office, you have to take the will and file it, petition the court to be appointed the executor according to what the will says, and wait for your letters of office. So what is probate? What is probate? Because you have to go to probate court. To get that money from your dad's account, the bank won't give it to you without letters of office. You can't get the letters of office without going to probate court. So what is probate court? What does it do? When you petition the court to approve the will, to give you the letters of office, the court examines the will to see what it says, to see if all the formalities were followed. And if the court finds, after its examination, that it's a good will, then 2 weeks later, it will issue your letters of office to you, and you can take those letters of office to the bank and get your dad's money and open an estate account. So those are the effective documents, those letters of office. And the letters of office are really just the beginning, though, because when you probate a will, when you take the will to court and you show the court that the will is valid and the court issues the letters of office, you have responsibilities to the court that come with the letters of office. You have authority to act with the letters of office, but you can only act pursuant to the directions in the will. And you're responsible for administering the estate according to the will. So that means, like we said, paying the debts of the estate, paying the taxes, the federal and local taxes that you may have to pay, any expenses of the estate, and then making sure you distribute the remainder to the heirs, and then you have to close the estate at the end of the process to the court's satisfaction. So the court is involved the whole way through in probating your estate. So it's a common misconception that once you have a will, you avoid probate. Having a will almost guarantees that you're going to go through probate, because when you have the will by itself, it's almost not effective to do anything without first obtaining the letters of office. So we've been through a lot in this show. I want to thank you for spending some time with me today. We've talked about what a will is, what it does, why you need one, and 5 big things you should know about using LegalZoom to draft your will. Just to sum up, the first thing was that I understand that lawyers can be difficult to work with. Secondly, LegalZoom's not a bad product. It's cheap, fast, convenient, and so on. But before using a LegalZoom will, you need to know that a LegalZoom will or any will won't cover all your assets. It won't cover every situation you may need to plan for. And also, you'll have to go to probate court anyway, and you'll almost definitely need a lawyer in probate court.